If you would, Mr. Linton, state your name, whom you represent, and of course you have 5 minutes.
Do I need to press? No, I see where I'm going. My name is Paul Linton. I'm a special counsel for Texas Alliance for Life. I'm testifying today in support of Senate Bill 9, authored by Senator Paxton. First, a little bit about my background to testify today. I've been a practicing attorney for almost 50 years and have spent the last 30 years professionally engaged in the pro-life movement, first at Americans United for Life in Chicago, and then in the last 24 years in my own practice. I've been counsel of record for Friends of the Court in more than a dozen cases before the U.S. Supreme Court, including landmark beginning of life and end of life cases such as Webster versus Reproductive Health Services, Cruzan versus Director, Planned Parenthood versus Casey, Washington versus Glucksberg, Vaco versus Quill, Stenberg versus Carhart, Gonzalez versus Oregon, Ayotte versus Planned Parenthood, Gonzalez versus Carhart, and Gonzalez versus Planned Parenthood of Federation of America. In both Webster and Casey, I represented hundreds of state legislators, including Texas state legislators from both the Senate and the House. In Guam Society of Obstetricians and Gynecologists, I was appointed as a Special Assistant Attorney General for the territory of Guam and defending Guam's abortion statute. I've been counsel of record for Miki Courier in scores of cases in most of the federal courts of appeal and more than half of the state reviewing courts of the United States, including the Texas Supreme Court and several of your Texas reviewing courts. Turning to the legislation at hand, Senate Bill 9 would restore legal protection for unborn children from conception to birth upon a decision of the Supreme Court restoring the authority of the states to prohibit abortion or the adoption of a federal constitutional amendment that would do the same. SB9 would prohibit abortion throughout pregnancy, except in very narrow circumstances, which are essentially the same as those under which abortion after 20 weeks may be performed in Texas. Life of the mother and an extremely narrow physical health exception. Now, the first question that might be asked about this legislation is, why is it necessary? After all, Texas has never expressly repealed its pre-Roe abortion laws. That's true. Although it hasn't expressly repealed them, you have a decision from the Fifth Circuit Court of Appeals in McCorvey versus Hill holding that the enactment of post-Roe laws regulating abortion repeal by implication the pre-Roe laws prohibiting abortion. That decision is not binding on any state court, but it places a cloud over the status of the pre-Roe laws, and one of the purposes of this bill is to eliminate that cloud. It would ensure that Texas would have a law in place to prohibit abortion upon the overruling of Roe without having to enact yet another law. Let me emphasize, as the author did, under this law, the woman herself could not be prosecuted and could not be the subject of any civil liability for it. At this point, I'd like to say a few words about the circumstances under which the criminal and civil penalties authorized by the bill would go into effect. These have been outlined already by the author. There's nothing novel or unusual about having a law that becomes effective upon a future contingent event. This is done in a variety of contexts. Texas, for example, has made statutes take effect upon identifying and securing adequate state funding, federal funding, upon the concurrence of other states or the concurrence of other states in the federal government, or upon the enactment of federal law authorizing imposition of a sales tax on remote sales. In addition, Texas has made certain provisions of criminal law take effect upon a future contingent event, which in the case under the Texas Controlled Substances Act involves automatically adopting the classification of laws prohibiting drugs by the federal government. None of this involves an improper delegation of legislative authority under Article 2 or Article 3, Section 1 of the Texas Constitution. Unlike the abortion bans that have been enacted in some other states, this does not require the action of any third party to make it effective. That's intentional. Requiring the action of a third party like the Attorney General or the Code Commission or someone else, that places in the hands of a third party the ability to nullify the law if that person is hostile to the legislation or merely indifferent. So I would suggest that this is the proper approach. This is the one that's being used by 4 other states and is being considered by Ohio. Finally, a comment about the issue of notice. It's a basic principle of due process of law that you're entitled to notice that your conduct could be criminal. And this is provided adequately by the 30 days notice that's provided under the law. And I would point out that Texas has the authority under the Constitution of its state to make a law immediately effective upon passage, in which case there will be no notice to anyone. So there's no question about the adequacy of notice here. Finally, I would be happy to answer any questions that members of the committee might have. Thank you for your attention.
Thank you, Mr. Linton. Members, questions of the witness? All right, hearing and seeing none. Thank you for joining us today, Mr. Linton. Thank you.